afternoon. Welcome to the July 21st session of the Cape Cod Regional Assembly of Delegates. We'll call this meeting to order, and we will begin with a moment of silence to honor our troops who have died in service to our country and all those serving our country in the armed forces. Thank you, and now we'll stand for the Pledge of Allegiance. The clerk will call the roll.
Richard Anderson.
Present.
Ronald Bergstrom.
Here.
George Bryant. Leo Kukunas. Christopher Kaneda. Thomas Keys.
Here.
Marcia King. Here. Thomas Lynch.
Here.
Teresa Martin. John Oman. Paul Pilcher. Anthony Scalise.
Present.
Fred Schilp.
Here.
Charlotte Striebel. Here. Julia Taylor. Here. Mr. Speaker, we have a quorum with 84.73% of the delegates present.
Okay, thank you. I now need a motion to approve the calendar of business. Okay, been here a second? Second. Been moved and seconded. If there's no further comment, all those in favor say aye. Oh, we have a comment. Leo.
Thank you. I don't have a printed copy in front of me, but I did read them, and I noticed that I was on the list as being listed as absent, and I believe we had a latecomer come in, and actually in the minutes it says that I was in the parking lot on my way. So I don't know how we amend that. Do I get listed as absent with late, or because I was there?
The calendar, you're premature. The calendar of business is the agenda you have in front of you.
Oh, I'm sorry.
But
I think we have to take a vote on that. I'll take that back.
all right, so we'll approve the calendar of business, and then we'll address your issue. So all those in favor of approving the calendar of business, say aye.
Aye.
Opposed? Okay, now we need an approval of the Journal of July 7th, 2010. Do I have a motion?
Mr. Speaker, I move to approve the Journal of July 7th, 2010 as presented.
Okay, do I have a second? Second, Leo?
Mr. Speaker, may I answer Mr. Kukunas, Delegate Kukunas' question?
Yes.
I'll pass this down to you in a moment so you can look at the journal again. We note at the beginning that you're absent. Right after the listing, we say Mr. Kukunas arrived at 4:08 p.m. and Mr. Keys was late that day too. And we show that Mr. Keys arrived at 4:10 p.m. So it's just when we do the roll call, and then as the delegate comes in, we reflect that they've arrived.
Thank you.
Thank you.
Okay, is a motion on the table to approve the Journal of July 7th. Is there any further comment? Hearing none, all those in favor say aye.
Aye.
Opposed? We do not have with us today any of the county commissioners, so I guess we can't communicate with them, so we're going to have to move on then to, and I do not see Attorney Troy here either.
If I may, Mr. Speaker?
Yeah.
I told Attorney Troy that he would be on the calendar after the county commissioners, and I expected that would be somewhere around 4:15. When I told Attorney Troy that, I had no knowledge that the county commissioners weren't going to be here. I did speak with Attorney Troy's office today, and I know he's coming, so if we could wait, that would be wonderful.
Okay. Well, I will ask then if there are any communications from public officials. Are there any communications from members of the public? I see a member of the public. Please.
Jerry Rappaport, League of Women Voters.
Make sure your mic is on.
There, okay. Jerry Rappaport, League of Women Voters. I just wanted to let you know that we are planning a forum. The League, the Falmouth League, the Cape Cod Community College, the Interfaith Council, the whole group of individuals, is to save the date for September 19th at the Tilden Arts Center on Is Disrespect Killing Democracy? A public dialogue, because we hear so much about the lack of respect in public meetings. So We hope you will join us, and we will examine modern civility in the public and political arena. I'll send it all email tomorrow. Okay.
We have a question from Delegate Louis.
Okay. Yes.
I'm sorry, I wrote down September 19th, but you went too quick as to where it was.
It's at the Tilden Arts Center Community College from 2 to 4.
What
Sunday
day of the
afternoon.
week is the 19th?
Sunday, yes.
Thank you.
Thank you.
Hey, thank you. Well, I guess we're going to have to wait a few minutes for Attorney Troy. Turn on that music from Jeopardy, the ding, 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 and we'll see how long it takes him to show up.
No cholesterol. Heart rate. Make it better. I thought you were still going to run both offices. They just come in and do
If you can make it next year, you drive right up the
You're the open space committee.
Roadhouse is more.
How you doing?
Hi, how are you?
Good. Haven't seen you for a while.
And again, I have otherwise everybody else will and all of us, I'm very self-serving because I just call them about me.
Order in the court. Hi, welcome. Well, we're still in session, so...
Okay, thank you.
Write down and you can begin whenever you're ready.
Okay. The men in black are lawyers, so be very careful. Tell anyone.
What do you need? You brought two colleagues?
Yeah, we do, and actually we have all parts of the Cape here. This is Brian Wall, my partner, and Brian is from Brewster. He served on the planning board in Brewster at one point, and he does a lot of work. He does a lot of work in Falmouth, a lot of land permitting type things. And this is Craig Jordan, and Craig is from Sandwich, and he recently joined us at Troy Wall. And actually, we've done kind of some seminars on the open meeting law. And when I was getting ready the other day, I'm saying to myself, well, why don't I share the load? So what we did, and we're going to try to do it very quickly for you, is divide up the task and try to synthesize it, because we know you're already familiar with the open meeting law. And so we're just going to try to bring to you the nuts and bolts of it, and then if you have questions, that's what we'd like to answer for you. And if we don't know the answer, we're going to be honest lawyers and tell you we don't know, we'll get back to you. Because one of the questions that Diane raised in her initial correspondence is very much on the money, as Diane usually is. And that's the question, the intriguing question of whether the Assembly of Delegates is even under the open meeting law given the new definition. So So there is a process by which we can actually ask that question and get you an answer in writing. But for today's purposes, I can tell you that the Attorney General has preliminarily decided that the Assembly is subject to the open meeting law, and therefore what we really need to do is look at, you know, how this has changed and how it affects you. And in some ways, I would say there are two things that I think that you can see that it is really not designed for the Assembly if you look at the language, because it keeps on talking about the chairman of the board. But I've said to the towns, and I say here, that I assume the chair would be the speaker or the deputy speaker if the deputy speaker is presiding. And in that case, there are particular responsibilities for the speaker and the deputy speaker under the new law that weren't under the old law. And we'll see those as we go through. And as a secondary matter, I think that you will see that the new law's principal effect is that it has really brought into play electronic communications. And we say all the time to our, you know, public officials, be very careful about using your computer. There's all kinds of examples where in the towns, just recently in one of the towns I work in, we just seized a computer because we needed to see what was on it. This, as you'll see, not only extends to the computer that you might use in your official capacity if you're in a town, but it also extends to your personal computer if you're using your personal computer for government business. And so you be very, very careful about these communications. So what I propose to do is we're going to look at three definitions. There are three key definitions, and then very quickly just summarize the other sections, and then see if you have any questions that we can answer. And as I say, if we don't have the answer, we'll tell you and we'll get back to you. So what we're going to look at, you have a copy of the statute, I believe. We're going to look at, I picked of the three, we're going to do deliberation, meeting, and minutes. I'm going to do deliberation very quickly. Brian is going to do meeting, and I'm sorry, not minutes, public body. Craig is going to do public body. So I think deliberation illustrates what I have initially said, is they have said it's an oral or written communication through any medium, including electronic mail, between or among a quorum of a public body on any public business within its jurisdiction. And then it goes on to say that certain procedural matters are exempted. And there's a very important part of that is that if you're talking about procedural matters, make sure that you don't express any opinion. Now, one of the things that we have just come up with, I've just been dealing with recently, is this question. If one person sends another person an email that's on the same board and expresses some type of opinion, but copies the other people on the board or commission or on the assembly, is that covered within the exemption? And I think the answer is no. I think you are subject to the open meeting law, so you have to be very careful. So for instance, if Charlotte sends to Tom Lynch something saying, you know, I was thinking about such and such, and, you know, I really believe that, you know, and just kind of thinking out loud and thinks she's just talking with Tom, but is copying everybody, that is going to be a deliberation, and you're going to be subject to the open meeting law, and that is, you've got to be clear on that. So I think that the key is if you are going to use electronic mail or you're going to use oral communication, you have to make sure in order for it to be not a deliberation, you have to make sure that you are limiting it to just two people. And that this is a very important definition, because if you look at the definition of meeting, which Brian is going to do now, a meeting has to include a deliberation. If you are all meeting together and you're not doing anything and you're not doing any public business, then you don't have a meeting. You're outside the open meeting law. So with that, can I turn that to you? I'm sorry.
Craig switched on that.
Oh, you did? Okay, apparently they've switched to silence.
I'm going to take that one. The new open meeting law, the definition of meeting is fairly broad. It's any deliberation by a public body with respect to any matter within the body's jurisdiction. Now, that second phrase, with respect to any matter within the body's jurisdiction, is construed fairly broadly as well, in any matter that could be regularly assumed to be before that public body is deemed within its jurisdiction. However, there are 5 exceptions to the meeting requirement. One is on-site inspections of a project or program, as long as the members don't deliberate while on the inspection. The second is the attendance of a quorum of a public body at a private or public meeting, so long as the members don't deliberate. That includes training sessions, conferences, media events, or any other social event that a quorum of the public body might be attending. Fourth is a meeting of a quasi-judicial board or commission held solely for the purpose of an adjudicatory hearing. For example, a licensing issue that comes before a board that has the authority to issue that decision, that's a quasi-judicial board, and that is exempt from the open meeting requirements. And the fifth would be a session of town meeting held under Chapter 39. And with that, Brian?
And let me just add here, too, because Diane had also asked about when the county commissioners come here. I think Section C is material to that. Attendance by a quorum of a public body at a meeting, which is your meeting, that has complied with the notice requirements of the open meeting law. In other words, you have complied with the meeting, you have scheduled and posted the meeting, the county commissioners come, as long as the visiting members communicate only by open participation in the meeting on those matters under discussion by the host body and do not deliberate. They're not acting together to make a decision, they're just talking to you. That is outside, that's an exception to the meeting, and therefore that gives you some more flexibility. And I know that Diane had also raised the issue about, and I want to raise it now because this is at people when they come to a meeting, for instance, members of the public who have questions. You obviously can't anticipate what people are going to say or ask or concerns, and the question is how much flexibility do you have to deal with those, because you obviously, we value very much, although in the statute it says you don't have to have participation by the public, but I know that the Assembly is very interested in hearing from the public, and you don't want to be constrained by that. And so I think that the answer is, looking at the law, is there is no limitation on what anyone else might say, and you can listen, and you can engage in dialogue with them as long as you are not deliberating, as long as you're not coming to the point that you're making a decision. When you come to that point and you think that, you know, the Assembly is moving to that point, then the Speaker, I think, has the obligation, or the Deputy Speaker, if he is presiding, to say, we need to post this on the agenda. It looks like we're coalescing towards some decision. Sorry.
I was asked to talk about public body. The new statute defines public body, and I'll paraphrase, as a multi-member board, commission, committee, or subcommittee within the executive or legislative branch or within any county, district, city, region, or town, however created, elected, appointed, or otherwise constituted and established to further a public purpose. We were aware from Diane's letter that there was some questions regarding whether or not the Assembly of Delegates falls within that definition, and Bob and I discussed it, and we believe that the language regarding within any region covers the Assembly. And as a preliminary matter, we did call the open meeting department of the Attorney General's office and received a telephone opinion that it's their office's opinion as well that the Assembly of Delegates does fall within that definition. There is a provision in the new law that allows the Attorney General, who's the new enforcement authority, to issue advisory opinions by letter. And so if the Assembly of Delegates feels that that's something that it wants our office to do, that is something that we could follow through on in the future. I think it's worth noting that the new law specifically applies to subcommittees, and under the old law, if the body met and it was less than a quorum, then the meeting was not covered by the open meeting law. But now subcommittees of a body are specifically included in the law, and so if you decide, and I know that you have several standing subcommittees, if those committees and bodies meet, the open meeting law specifically applies to those meetings.
And therefore, in deliberations between a subcommittee, the same rule as to the whole thing. So, for instance, if you have a subcommittee of 3 people and one person is talking to another, you've got a quorum. you got to be very careful about that.
Just, Tom, did you want to have a question?
Thank you. Attorney Troy, with that definition of body, can you think of any body within the state of Massachusetts that falls in the exemption and is not subject to the open meeting law?
Well, I'm not sure I understand the question.
Is there any government body, subcommittee, group that is exempt from the open meeting law, that is legislative or executive or subcommittee?
I paraphrase the definition. The definition does go on to specifically exclude several entities. The general court, the legislature of Massachusetts is specifically excluded. Constitutional officers, which means the governor, the lieutenant governor, secretary of the Commonwealth, are specifically excluded. Certain advisory committees to those constitutional officers are exempt. But as far as the assembly and other like entities, when we spoke with the Attorney General, he specifically referenced the fact that he was aware that there were many such bodies out in the Commonwealth, and that it was his opinion, at least his singular opinion, that this new law does cover such bodies.
Thank you.
If I might say, when we did this in Bourne, one of the things that got a laugh was, one of the first questions was, is the legislature subject to these provisions? And of course, this is the classic case where they've exempted themselves. You may know from your own town councils or city solicitors, town attorneys, whatever, that the City Solicitor and Town Council Association, which is the association of the lawyers who represent the different towns in the Commonwealth, very strongly oppose this legislation because it is a specific imposition, particularly on the more local parts of government, and that as you go up the ladder, the veil of secrecy, particularly when you get up to the state level, is pretty broad, and that is, that's been noted, but I won't say any more.
All right, you want to finish your presentation, then I'll open it up to the Assembly.
Okay. Craig is going to briefly talk about the enforcement, which has now been taken away from the district attorney. And I might add that I was talking to Michael O'Keefe and the district attorney, assistant district attorney was handling it. And I kind of agree with them that here in Barnstable, in terms of the Cape and the Islands, things went very well. The DA's office did a very good job in handling the open meeting law. So to some extent, there's also been concern in terms of enforcement and its entire ability to be enforced. There's some concern that at the state level, everything up at the state, that they're going to be able to do as good a job as they were able to do at the local level, because as you know, at the local level, there's a greater familiarity and understanding of who the players are, whereas, in Boston, to deal with the 356 cities and towns, that's a big item, and we'll see.
Actually, we're going to get into some of the more specifics of the complaint and investigatory procedures in a moment, but right now I think it'd be important to discuss the structure, the new setup. It's essentially, there's a new agency under the Attorney General's office. It's going to be considered the Division of Open Government, and the division can issue advisory opinions, and they're responsible for preparing educational materials and holding training seminars on the implementation of the new open meeting law. And each year, the Attorney General's office has to prepare a summary and provide to the advisory committee, giving the number of complaints that are brought regarding the open meeting law each year, the number of hearings convened by the Attorney General's office, a summary of the violations, a summary of all orders that are formally issued, and accounting of all the fines obtained.
And Now let's look at the issue of the notice. Section 20 provides that there be notice, and it makes a change. Now, it used to be when you computed the 48 hours, you had the benefit of the Saturday and Sunday. You no longer can use those. They can't be included in the computation. So, for instance, as a practical matter, this is what we've said, boards, towns that used to meet on Monday night used to be able to post their agenda on Friday. Now they have to move the agenda back to Wednesday by the time it meets, because you need a full, or at least Thursday, I guess, you need a full 48 hours of business time. And, you know, that creates a problem, but that's what the law is. And the most, I think, important change is now the agenda is not just a broad or a flexible route for the meeting or map of the meeting. The chair, which would in this case would be obviously the speaker, has to, in addition showing the date, time, and place, has to have a listing of topics that the chair reasonably anticipates will be discussed at the meeting. And that's, of course, is very difficult, and it goes to what Diane's concern was about a member of the public raising an issue that the chair would have no idea that that particular person was going to bring up, and, you know, is that going to be a violation? And I think that all we can say is the chair can only do its best. The speaker, in this case, can only do his best or her best, whoever's speaker, to kind of anticipate what is going to be at the meeting. It has to be posted. The notice has to be filed at the office of the county commissioners, and also has to be publicly posted at some place where the public can see it at all times. I know a lot of the towns are constructing outdoor little bulletin boards and things like that, and, you know, that's a burden, but I think the Attorney General has said that if you put it at the police station, for instance, and the police station is open, you know, that satisfies it. I don't know what kind of plans the county has made on that. I don't know whether you know more about that, Diane, but that is required. And in addition to that, there are several other provisions. I'm not going to get into detail, but one that I think is important is that if any person may make a video or an audio recording of any open session of this body, as long as they notify the chair ahead of time. And the chair has discretion to you know, locate where the equipment's going to be, but other than that, that is a person. And one of the things that I think is very helpful in this is that in this particular codification, it recognizes the principle that a lot of people do misunderstand, is that participation by the public is at the discretion of the public body. I mean, somebody who is either speaking out of turn or out of order or not pertinent or does not have a right, and the chair is authorized to order the person to leave the room, and if the person doesn't leave, the chair may authorize the constable or other officer to remove the person from the audience, which we're waiting to see when that happens. Someplace it's going to happen, and I'm sure it's going to be a headline. And and then there's the requirement that people who serve in public body, once they are qualified, they have to sign that they have received a copy of the regulations and that have been promulgated. Executive sessions, I'm sorry, do you consist?
Before we get to that, the regulations provided by the Attorney General's office, they're temporary. There's going to be a notice and comment period coming up in August for the public to post concerns, but they have provided some temporary regulations, and one of them also addresses the issue of notice, is that the public body has to file with the Attorney General's office their posting method, and they have to inform the Attorney General if there's any change in posting method. So, I mean, there's probably just going to be a huge stack of every public body and agency in the state of how they post their notice requirements, and it's one of the new regulations.
Executive sessions are the exception to the rule that all meetings have to be in public. Executive sessions allow the body to meet privately outside of the public eye. There are certain restrictions, which I'm sure you're familiar with, and the process is the same basically as in the old law. There has to be a stated reason given for going into executive session. The reason must be specific, and it must be one of the 10 exceptions that are listed in the statute. The new statute does provide that the chairperson must now state for specific reasons, including litigation and collective bargaining, that going into executive session is necessary because an open session would be detrimental to the body's business, and that's a new requirement. The statute also does contemplate more detail being given for the reason. I think past practice was simply to discuss pending litigation. Now you have to give more information to the point, up to the point, without prejudicing the reason for going into the executive session in the first place. There are 10 reasons given in the statute that are listed, and I won't go through them because they're basically the same as the ones before. There are 3 of them that are very important, though, that are worth mentioning. One is discussing an employee's reputation or matters of discipline or dismissal. That's permissible for executive session. Strategy sessions regarding personnel and union contracts, and obviously litigation. There is a new provision that's been added to the new statute that might be relevant to the county's business, and that's specifically to discuss trade secrets or proprietary information in the event of a governmental body acting as an energy supplier. And so that might be relevant for business involving the Cape Light Compact.
The next section is minutes. We just have a couple more sections here, and I think the key change in the law now is that executive session minutes are different. You used to have to always put the date, time, and place and the members present. You now have to put the members that are absent. But most importantly, in executive session, you have to have a summary of the discussions on each subject and a list of documents and other exhibits used at the meeting and the actions taken at the meeting, including a record of all votes. So it's made it much more rigorous. One of the things that is of concern is this summary of the discussions. That can be a very difficult thing to do, and to some extent there is a question of whether or not that summary, when it becomes public, defeats the purpose of the executive session, because the idea of the executive session was to have the governmental body be able to discuss things, not having the concern about it subsequently being made available to the public and discussed. And so that has been, and I think there's going to be regulations by the Attorney General that clarify that. My recommendation is that, the public bodies be concise and not try to make it, anything that approaches, a transcript type thing, but just some kind of, a summary is a summary, and I think that's fair. And the votes have to be done by roll call. That basically is the same. But the minutes are, after you have a public request for an open session, the minutes have to be provided within 10 days, which creates an administrative burden for staff, because a lot of times between meetings, you may not have approved them. There is a process, and that the minutes, it says of an open session, if they exist and whether approved or in draft form, have to be available within 10 days. So you can't wait till the next meeting to have them approved. And any documents or photographs, recordings, or maps, they are part of the official record. The minutes of any open session are public, except for performance evaluations or materials about deliberations about employment or appointment of individuals. Except, they said, a resume submitted by any applicant for any position, that's not exempt. You have to produce that. And the minutes of the executive session for matters which are allowed to be withheld, there is a process through which, I'm not going to go into it in detail because it's all set forth in statute, but there's a process by which those minutes are approved for publication, and there are matters, attorney-client privilege and such. It's a more complicated thing, and I'm not going to use it in this summary. The only thing I do want to note on under this is the public body or its chair or designee, which means the speaker can do it or he can designate someone to do so. They're supposed to review the minutes of the executive session to determine compliance with the section, and they announce when there's a determination that they're public, and that's recorded in the minutes. So there's really a very close paper trail on executive session and what's happened at the executive session and how and when those things are released. And finally, there is the new section of the open meeting law that Craig is going to talk about that is different. Before the district attorney was the enforcement, this allows public enforcement by citizens, and this is going to lead, I believe, to a considerable amount of litigation statewide as different members of the public want to have access to records.
There's actually two processes that the Attorney General has set forth for dealing with complaints. The first is a formal complaint before the board. The aggrieved individual, within 30 days of the alleged violation, is required to submit in writing the request for either, compliance with the law or the opening up of public records. Within 14 days of that, the public body has to submit it to the Attorney General's office and then also address the individual and try to resolve the concerns at the local level. The Attorney General will make a determination whether a violation has been committed and also will ask the public body to report on any remedial action taken to resolve the dispute. Now, the Attorney General is fairly broad authority. They can compel attendance at an open meeting law training session. They can issue fines of up to $1,000 a day for intentional violations. They can nullify agency or board decisions in whole or in part. And there's also that catch-all provision, which allows the Attorney General to prescribe any action deemed necessary to resolve the issue. In addition to that, there's also a process for judicial review. Any aggrieved person can petition for review in Superior Court within 21 days of the alleged violation. And in the order of the Attorney General, the order submitted to the public body will be stayed pending the resolution of the proceeding in Superior Court. Additionally, as Bob had mentioned, there is a public enforcement requirement. 3 or more citizens can compel an action in Superior Court to enforce the open meeting law as well. The Attorney General can hold a public investigation, but they can also do an internal informal investigation, which could involve a phone call or a letter asking for the matter to be resolved.
And just to add, there is section G of section 23 has a very interesting and important defense, almost a...
Would you turn that microphone on, please? It must have turned off.
Okay, sorry about that. The section G of section 23 says that when the Attorney General makes an investigation, it shall be a defense to the imposition of a penalty that the public body, after full disclosure, acted in good faith compliance with the advice of the public body's legal counsel, which means that if you make a mistake, but your lawyer has told you to make the mistake, you're free. But obviously, the lawyer is not going to claim any credit for that, that victory.
The next section of the law empowers the Attorney General to enforce what you just heard in the prior section, and it basically states that the Attorney General, now different than the District Attorney, may, upon reasonable cause to believe that a violation has occurred, can conduct an investigation. The law also imposes upon public officials and members of the body that are at issue an affirmative obligation to cooperate with the investigation, and if the person does not cooperate, then the Attorney General has certain authorities to require involuntary cooperation, including compelling the person to appear, to testify, or to produce documents. And I would suggest that if the person does not cooperate, it would also constitute an independent violation of the statute.
So there we are. I think we've given a summary, and if you have any questions, we're happy to try to answer them. And if you don't, I'll turn it back over to the speaker to
Question? Troy or his associates on this, Tom?
I have some questions around the agenda and then information that might need to be posted around the agenda. Just looking at today's, we have communications from County Council Robert Troy. Should we have had the statute listed? I mean, to be more accurate as to what was actually going to be discussed, should it have said chapter blah, blah, blah? When this notice is posted, or when of our meeting, do we need to provide that statute at that point in time, so if someone wants to attend the meeting, they can see that, or should that be available to them? So there's those questions around what's posted, and then once we've conducted the meeting, you've referred to other documents other than just the open meeting law, new regulations that the Attorney General might have issued, some draft regulations. Do you have to, as a presenter, give to us, as part of the record, that information that was used in presenting this? Because it seems like they're going into great depth here in terms of what you need to retain as to when we had this discussion. And then my final one would be, when we post the minutes, do we then, like, let's say, after the minutes are prepared, Diane has sent them around, does she have to send around copies of those documents electronically so that we know what constitutes those minutes? Should a citizen say what happened at that meeting, and we'll say, or refer to X date, and here are the documents that are there? Can you?
I think that, of course, the burden of anticipating what's going to be talked about at a meeting, that's a very difficult. You don't know, for instance, what the different members, intend necessarily to talk about or say, and you don't know whether the meeting is going to veer off the agenda. So I think what you have to do, and this is the Speaker's responsibility, and it probably devolves to Diane, is that you have to do your best to list the items with as much specificity as possible. I think your point is a good one. Most bodies get some type of documentary preparation for what's going to be on at the meeting, and I assume you do too. As a matter of fact, I know that you had some memos that I sent. That actually becomes part of the record of the meeting, and you probably, when you're preparing your record, want to scan all those documents so that you have an electronic version of the entire meeting. So, for instance, on this today,
do they need to be available to the public before the meeting takes place, so they know?
Not before the meeting. No.
Okay.
Yeah, after on the open meeting, that would be after your meeting is done. You're going to assemble everything. You have the advantage here, of course, of having a transcript, a stenographic transcript, which a lot of bodies don't have. So you're going to have that, which is pretty, thorough, and you're going to have all of the documents that you have been provided. They're going to be scanned, they're going to be part of the record. So you're probably going to have a pretty big record of the meeting, at least of the open meeting. But I do agree, and I don't mean this in any way I think that the law envisions, and it's going to take everybody time to kind of step up to the plate, or unless the legislature, there is pressure in the legislature to amend some of these provisions. I think that the agenda has to be a little more specific than what we have today. So, for instance, when you have communication from public officials, number 10, if you know who they are, if you know, for instance, the Board of Selectmen of Yarmouth are coming, or the town, manager of a town is coming, then I think you have to put that on. Or there's another, it does need to be a little more specific. But I think that the record, to answer your question, the public doesn't see what you see beforehand, but after the whole meeting is completed, there is a public record, so they're going to know exactly, what you saw and what you had in terms of the background, which might have motivated some of the concerns in the discussion.
Okay. Let me ask you, cut to the chase here. before I was Speaker, I used to sit down in that corner, and we would, sometimes the meetings went on for a while, and we'd get down to the last two items, which would be other business and adjournment. So I would always be looking toward adjournment because I was close to the door, and I figured I'd be out and I'd scoot out. But whoever was presiding, I think it was the previous speaker or even the previous to her, would say, is there any other business to be brought before the board? And I would hold my breath and nothing would happen. All of a sudden, a hand would go up and then somebody would say, you know, what about that budget item that we talked about last week? Or how about that grant that was given to the county, you know, what's happened to that? And so it would start out as an informational question, but invariably might lead to someone say, well, I think that was a bad idea, and somebody from the other side would say, well, you know, I think that was a good idea, I think we should have done that. So we immediately lend into deliberation, and then, of course, the question is, do you try to draw a balance between an open discussion, I mean, this is a deliberative body, an open discussion of issues, and the intent of this law, which says that if the public has to be given notice as to what is going to be discussed. So at what point does it become it go from informational to basically where you're deliberating? And that's really the question I think everybody who presides over a body like this has to ask themselves.
And I think that's a very good question. And frankly, I think this is one instance where the law has a disappointing answer. If you look at you know, I agree completely that if you're going to talk about other business, there has to be some ability. Everything can't be all postponed to another meeting. Someone may have a question, for instance, that one of their towns wants an answer, an informational question, and you have to be able to get that information in a contemporaneous fashion. You can't be waiting for a meeting in a week or two. So you have to be able to get information. And I think that the question that you raise is a good one, is when the information is provided, then it spawns a discussion and you move towards deliberation. Actually, the responsibility to govern that is the speaker or the chairman of the committee or board or whatever. I've told the chairman of the Board of Selectmen is a new job, and actually right here, the seat over at the corner is probably going to be looking pretty good because there's a lot more work for the speaker. But I think that the answer to it is the definition of deliberation when you look at it, an oral or written communication between or among a quorum of a public body on any public business within its jurisdiction is very clearly overly broad. That is a very difficult, and that needs some work. That definition I don't think is going to work. But I think that you know that when it gets to the point that you're morphing into a discussion of some type of policy and you're moving towards doing something or changing, then at that point the chair says, well, this is really getting to the point that we're moving into the area of deliberation, and we need to schedule this on the agenda, and then you put it on an agenda.
I've seen, sometimes I'll see congressional investigation into something, and there'll be, you know, the senators will be sitting up there, and they'll ask a question of whoever the poor witness is, maybe Secretary of the Interior or something, and I know, and everybody else does know, that the question is actually just a segue into what that particular senator wants to say about the whole thing. It's not like court where you just ask questions. They'll say, well, and so they'll take the answer, and then they'll go off for 45 minutes and say, well, I think that's just awful and stuff. So, I mean, I understand the intent of the law, and this also goes to the communications from county commissioners, which theoretically is them reporting to us what has been going on, but can also lead to a discussion. I mean, obviously, we're going to ask them substantive things about the county. So I recognize that it's the speaker's responsibility to judge when we go into a deliberative kind of conversation. But I agree with you. That's very vague and very difficult to enforce under realistic circumstances. You know, I mean, at some point we have to say this is too involved to really. The public should have been given notice that a certain item is going to be deliberated.
And actually, when you think about it too, even though it is obviously a benefit, one of the disadvantages to a stenographic record is that if you do, by omission, enter into the world of deliberation, there's going to be a very clear record, and your case is kind of complicated and exacerbated by the record, and of course you've got media, and a lot of the Townsend media. And as you know, what you're also going to have eventually is you're going to have people who are interested in a particular thing coming in and bringing their own media. And that's, you know, and then you realize they can take that tape and they can, you know, send it up to the Attorney General. And, you know, I think this is going to be, the legislature, you know, makes laws, and laws are business for lawyers, and I predict that this is very lawyer-friendly. There's going to be a lot of disputes about this.
You're really probably the only few lawyers that are not down the Gulf right now. I'm glad we could get three here. But the last question I have is that if let's say someone comes before the Assembly, whether it's the county commissioners or someone else, and brings up something, brings up something that's not on the agenda. Let's say it's public communications from members of the public, and an individual delegate starts to give their opinion. You know, the county commissioners say, well, we're going to do such and such with this grant, and they gets up and somebody says, well, I don't think you should do that. I think you should do something else with it. Now, we're not deliberating on that. There's no one arguing with him. He's arguing with the county commissioners who are not part of our body. So, I mean, at that point, that's a discussion, but it doesn't, in other words,
I agree. That's permissible. That's absolutely permissible, because you were not deliberating as a body, and the county commissioners are here under, you know, the exception. They're not supposed to be deliberating. It's not their meeting, so since they're outside of the meeting, they can kind of talk. But you've got to have. There's no point in having the assembly if the delegates cannot express their opinions. And so I think what happens is that if one delegate says that, and then as other delegates might join, then you might be moving into, and then the speaker has to say, well, you know, this really looks like we're entering we're crossing the line and getting into deliberation. And I think, to be cautious, we should post this and let the public know we're going to be talking about this. And that's what I think you have to end up doing. You're going to have to be kind of setting up the agenda for the next meeting. It's going to be a little more complicated, but after a while, I think you know, that part, I think, can work.
Anyone else? Fred?
Yes, thank you, Mr. Speaker. I guess my thinking about the communication from the county commissioners is probably for me, in sitting here listening, as we do every other Wednesday, listen to what business has happened for the past 2 weeks in the county as what's been reported to the commissioners. Some of those issues have maybe a week or 10 days lead time. Many of them happen the same morning. The county commissioners on Wednesday, that they are then talking to us about that afternoon, and there's really not an opportunity to even understand what the subject matter is. But it also is true that the county commissioners meeting that day was an open meeting, and was an open meeting for the public. So whatever was discussed at that meeting and their agenda was open to the public. Does that mean that, in fact, the public has had an opportunity to hear about those subjects? And the second part of that is when they come to see us, it's an informational session. Most of us are asking questions of them to explain further. Usually there is not a negotiation that's taking place or deliberation that's taking place. And I guess then it's up to the speaker to decide, you know, when that becomes deliberation and when it's just trying to understand, you know, better that business.
And you know, I think it has implications. I think, obviously, if you're talking about your meetings being on the same day as the county commissioners, that is going to create some problems in that area, because even though their meeting has been public, unless you were there, you don't know what transpired. When you think about it, the county commissioners are also subject to this law, and so within 10 days after their open meeting, they're going to have to produce the same kind of everything, all the reports and everything, which would give you a lot more information. You're going to be able to have their reports. But if you do it on the same day, you're not going to be. So I guess all you can do if the schedule remains the same is if it's something that you have a disagreement with the county commissioners, or you want to discuss it, or you want more information just to see whether or not you agree or disagree, you're going to have to say to the commissioners, we would want to get the record of your meeting and see everything that you did, and we want to discuss it, next week at the next meeting. And I think that's the only, fair way that you're going to be able to do it.
Put too fine a point on this, but of course it is a law, and it's going to be looked at, is that, let's say let's say Tom, the deputy speaker, says to the county commissioners, I disagree with your policy on something, and they may have just addressed, okay? Now, Fred gets up and he says to the county commissioners, I agree with your policy. I think it's a good one. So they haven't addressed each other. They're just talking to the county commissioners. Now, that could go on for 10 minutes. Now, if Fred would respond to Tom and say, well, I think you're wrong, Tom, and here's why, then that point, we're deliberating, it seems to me.
You're getting into that area, and that point, you need to have a discussion. And I actually think this part works, that you put it on to the meeting, and then you'll have the materials from the county commission. You'll have more materials. I mean, I think that the way that it works right now, the assembly is somewhat at a disadvantage, is that you're only getting an oral summary of what has transpired. If you actually, it can work in such a way that when you get their record and you have them come back, you'll be much better equipped, because obviously you're.
Well, I'm just wondering if we individually address the county commissioners without addressing each other, whether we would be sort of doing an end run around the open meeting law. In other words, would that be permissible? If, in other words, we're not deliberating with each other, we're simply objecting to or approving of a policy or something that they said.
Well, I mean, that's a very fine point. And that, I mean, I certainly think that you have to be, the meeting is not going to work. This meeting is not going to work unless you have some freedom to express your points of view. And so if you are either disagreeing or agreeing with the county commissioners, you're not actually, this is why the definition is so broad. It appears that invokes the definition of deliberation. But logically and common sense, unless you are kind of coalescing and taking an action that is either approving or disapproving with something that the county commissioners are proposing or have done, I mean, I think there has to be room for individual members to express their opinions. But when it gets to the point, and this is where the speaker is going to have, there's going to be a fine line here, that it looks like you're setting up some type of movement that the assembly is going to oppose the county commissioners on, then I think you have to post it. And as I say, you have the benefit of more information by the time your meeting comes around.
Okay. Leo, and then we have to...
You mentioned a couple of things briefly. The ability for the public to tape or record the meeting. Isn't there also a requirement in there that, or does the requirement go forward for us to notify people in the room that someone else is taping or recording the session, in case there are people there from the general public who wish not to be recorded? Or did I read that wrong? I only got one good eye, and I haven't been using that one too good today, so.
I'm not sure what you're referring to. Do either of you guys have
early on you had mentioned something about and I did remember reading in there this paragraph that said that...
Yeah, 20E says, after notifying that any person may make a video audio recording of an open session or may transmit the meeting through any medium subject to reasonable requirements of the chair as to the number. I mean, sounding like YouTube, isn't it? Yeah. But at the beginning of the meeting, the chair shall inform other attendees of any such recordings.
Okay. Yeah, so that means that it's our responsibility, if we know that someone has asked to tape it, right, it's our responsibility to tell members of the public who are here in this room that someone is taping it.
Exactly. And of course, I think that the law may not be known to the people who come to the meetings, so I think it's kind of incumbent at every meeting you say at the beginning that the chair says, if anybody is going to take any kind of video or audio recording, then they have to notify the chair immediately, and maybe you stop the meeting and you get people, because otherwise what you have, you could be in a situation where you are not aware that you are being recorded, and find out later when you go on YouTube that you were not notified.
Do you think it's, that requirement also covers us to notify that we are in fact taping and recording this session? And that should be mentioned prior to every meeting?
Yeah, I don't think there's any problem doing that. I don't think there's any, I don't think that, I think you're exempt, okay, the body itself, from doing that. But it's certainly not a bad idea to let everybody know, because increasingly, obviously, everything is being recorded.
Can I ask video? I know we discussed and we went over quickly, I think in Diane's letter also, sometimes we have listed here number 6, the approval of calendar of business, and we have in the past amended the calendar of business. That is no longer going to be allowed after this new law. Is that correct?
Well, it can be amended up until the posting requirement.
Right.
Yeah, I mean, you have to, as long as it's 48 business hours, the calendar of business can be amended. So it depends, you know, as long as you have a final version, 48 hours, business hours before the meeting, you're okay. So you can amend it and you can actually circulate it ahead of time. As a matter of fact, a good idea might be, you know, given this law, I mean, just as a practical matter, is if the if Diane notified you of what, you know, they were aware of, or she was aware of, staff of what was going to be discussed, and give you people an opportunity, if you've got something you're going to add, to add it to it, so you can, you know, to make the meetings work. You want to make the meetings productive. You don't want to be muzzled because there's some type of procedural roadblock from, you know, things you want to talk about.
And just one other thing real quick. Tom mentioned earlier, and he had asked specifically on number 9, the way it is written right now, it just says that, you know, your councilors were going to appear today and speak about the open meeting law. And he kind of suggested that it may have been proper to put the Massachusetts General Law, whatever the number is, 48L-9, after that.
I don't mean to interrupt you, but I just have to say that we're in danger of losing a quorum, and if we'll be okay?
We'll be okay. We're still, nobody else can leave though.
No, okay, you all have to stay right where you are, or else we have to end this meeting. All right, Leo, go ahead.
I kind of felt that maybe, and this is, maybe you can help clarify this, that if we added that particular Massachusetts General Law number, that it would actually limit you guys to only giving us information on that particular law, and in fact, you may want to say, well, you know, when you're here, you might want to say, well, you know, Mass General Law 4897 does not agree with that and gives you an exemption. So I'm wondering how precise and accurate do these listings need to be? Is Tom right in requesting that we should have had the chapter and verse written there, or do you feel comfortable that just having communications from, you know, the Councilor Robert Troy about the open meeting law is adequate?
Well, I don't want to say anybody's right or wrong. I would say this, that I think that all the law requires is a listing of topics. And so the topics is pretty broad. And the one thing I would say to you, too, in doing this is, you know, the legislature has passed some very stringent requirements, and you have to make sure you can do your business within those requirements. And I would suggest that you be, you know, you push the envelope in terms of maintaining as much flexibility as you can within what's the understanding of the law. And here, actually, this is a good example where I'm giving you some advice. So if you're called upon it, maybe this advice will be an exemption from punishment. But I think that as long as you do your best to put the topic that's going to be discussed, and you make that as broad as you can, because you want to have some flexibility. You don't want to be boxed in, because procedure is always an enemy of any kind of substantive process, in my view. You give the topic and you make it as broad, and I think the speaker should, you know, use discretion to, as long as it's roughly within that topic, you let it proceed. Otherwise, you're going to be in a horrible box where you have to put everything on. You're going to want to talk about something, and you're going to have to wait till the next meeting to talk about it. So I think that, you know, the broad topics are helpful. The only thing I said, for instance, communication communications from public officials. The way if you knew what public officials, you could put them down, but you could also put in the two and other public officials. You could add, because there may be a public official who comes to the meeting that you don't know is going to come, and you don't want that person to come here and not be able to talk. So you might, we can work with you on, giving you some help on that, but I would keep it broad.
Charlotte?
Thank you. I would just ask you about town committees, if I could. The minutes, you say how many days do minutes of a town committee meeting, you can send out a draft of the minutes?
They are due 10 days.
So you can't do them at the next meeting?
No, if somebody makes a public, you can do them at the next meeting, but if you have draft minutes and somebody asks for a copy of the draft minutes, you have to produce them within 10 days. And of course, that goes to a lot of boards record. That means the tape. You've got to give the tape. A lot of things. If you've got a film tape, you've got to give that too. I mean, I think we all know that because of electronics and communication changes, everybody is on a very tight leash now, and there probably is some. There's a way to get what is said at a meeting very, very quickly now. And as I say, the way that's probably going to happen if somebody is that you're going to find more and more interested parties, they're going to bring their own equipment, and they're going to have it that minute.
Because of the committee that I chair in Yarmouth, the secretary records the minutes and the action of what happened when for her ability to write up the minutes. That has to be.
Yes.
That has to be retained?
Yeah, well, it doesn't have to be permanently retained. After the minutes are approved, you then, I'm thinking through here, that's not completely clear, actually, because it does say that you have to have, well, what it says is documents and other exhibits such as photographs, recordings, or maps used by the body at an opening shall, along with minutes, be part of the official record. So I guess, no, they're not being used. That's just a tape recording of what's being done, which is used in preparation. But the question is, if the day after the meeting, somebody comes in and you haven't approved the minutes and they want a copy of the tape, you have to produce that tape within 10 days.
Okay, all right. Otherwise, I don't mean to keep repeating myself, but otherwise, if nobody requests the minutes, they can be approved at the next monthly meeting.
Yes.
They're sent out by email to all the members of the committee.
Right.
For corrections,
right,
if there are any. And then they're approved at the next monthly meeting.
That all works. The only time when there's a time frame that clicks in is as soon as somebody comes in and wants to request them. Okay. And you get 10 days from that point. So you're right. If nobody requests them, then you just continue the same practice.
Fine. Thank you very much.
Thank you, Mr. Speaker. I think my question is a fairly simple one. Frequently when we have our public hearings during budget season or whatever, any public hearings, nobody shows up. Now, if that happens, do we have to cancel the program, just continue on without anybody here, not worry about it being in violation of this law?
If nobody shows up at the meeting?
No public people, nobody from the public shows up. It's a public hearing and nobody shows up.
The committee meeting or the public?
Committee meeting.
Well, if you have a legally posted meeting and you have a quorum, you can go ahead and proceed. You don't need, it doesn't have to be a member of the public. Yeah, you don't have to have somebody there. But you have to keep a record of it. You're going to have to do this, yeah, all the same things. But, yeah, you're...
Thank you, Mr. Speaker. I have one other question about one of the first comments that you made was about personal computers and your computer, and be careful about your computer. I'm just curious, how do investigators, if they come in and take my computer, are they looking for keywords to be able to then find out which emails or documents how would they go through one's computer to find specific, and how would they then protect the privacy of the person whose computer it is?
Under the, under the investigatory provisions in Section 24 of the statute, the Attorney General is given certain authority to require the documents to be produced. And it's a new statute, so I'm just going to somewhat speculate, but I'm going to go based upon other areas of the law. The Attorney General would have an authority to issue an order reasonably describing the documents that they were seeking, and then the person would be obliged to respond to that and produce the documents. And I suppose it could come to the point where if the person wasn't complying or cooperating as the statute affirmatively requires, then the Attorney General could go to court and seek an order to seize the computer or go through it on their own.
I just want one more question. More of mine than it is this, but a lot of people, I've had the experience serving on a body, and there's a new member, and when it came time to approve the minutes, I would say if there's any additions or corrections, their hand would go up and they'd say, you know, it has me down as saying this, but you know what I really meant to say was this, and I should add at this point that, and it's a personal peeve of mine because I always thought you either said it or you didn't. You know, time has gone by and you either said it or you didn't say it. But I know that some deliberative bodies, U.S. Congress, they add stuff all the time. You know, after the, you know, and so what obligation do you have to accurately reflect what specifically was said? I mean, here we have a transcript here, so that's not an issue. But in other forums, minutes have been played with after the meeting is over. So,
well, yeah, and I think that the answer to that is that the statute says that a public body has to create and maintain accurate minutes of all meetings. What it actually says now, the date, time, and place, the members present or absent, and then a summary of the discussion. This is what we talked about before. I think that is an obligation of the public body. So if I say something, and we have all said things that as soon as we said them, we wish we had phrased them differently. It's the obligation of the body, and if the person comes and says, well, you know, I might have said that, but I didn't mean to say that, I think, unfortunately, the body has to use its judgment to insist on what everyone understands and remembers was said, and they kind of...
But the statute basically, even if it's not, you know, something somebody said wrong, but simply in the matter of deliberations, the statute says that you have to present an accurate record of what was discussed. Right. So it's not a verbatim necessarily.
No, absolutely not. No, and that's not going to help you. The more you get into a verbatim type thing, the more that's going.
So there's some flexibility in there as to if somebody would say, well, you have me down as saying this because sometimes, but I really did say something else. Okay.
Right, and my advice there on that too would be when a summary of discussions that you not you know, get into a level of detail which is you satisfy just the statute. You have a summary. You don't. It seems to me that you don't have to say. It doesn't have to be that person X said this and then Y disagreed and said what. A summary is a summary. Period. We discussed this issue and there was points of view on either way. I think that's the. Otherwise, you're going to take an incredible amount of administrative time to prepare these minutes, and that's money. That's governmental money being spent on this. So that's another part of it.
Okay, well, Diane has.
Thank you for coming. I'm sorry I didn't hear your answer to Leo about the amended calendar. I think I know the answer, but we were figuring out if there was a calendar. We were trying to figure out if we had a quorum. We cannot amend the calendar as we've done in the past at a meeting, because that would no longer comply with the open meeting law. We need the 48 hours.
Right.
And that's big, okay.
If the amendment of the calendar is such that you're adding a topic.
Yes.
I mean, if...
We've done that. We've
right.
added an ordinance to be
Right.
voted on that had
No,
not been on there, so.
You need to have that 48 hours, business hours, before the meeting. And what I suggested was that you can start the process earlier and circulate a calendar and let the delegates add to things. And as long as you have that 48, you're meeting actually Wednesday at 4.
Mm-hmm.
So you actually have a better situation than a lot of governmental bodies, because that just means that by Monday at 4, you've got to post your notice. So you've got, that's a pretty good schedule.
Okay. And then as far as email and deliberation, I think it was your December 09 memo where there were some problems across the Commonwealth. It's my understanding that there can be no deliberation, even one-to-one, one delegate to another, because of the possibility of that email being then forwarded or blind carbon copied, or did I read that incorrectly, or?
Well, the new law, I think, says, it says an oral or written communication through any medium, including electronic mail, between or among a quorum of a public body. So I think if you just have a discussion between two members, and it's not a quorum, then that is not a deliberation.
Okay. Well, that was, okay, that's...
But an email copy to everyone is. So that what I said at the beginning was, if Charlotte and Leo are discussing an issue, and Charlotte has one position and Leo is either agreeing or disagreeing with her, then if you copy everybody else, everybody is kind of in on it, in that it would be the same thing as if they're talking right here and everyone is silent and listening. You're doing the same thing, so that is a deliberation. So the answer is you don't copy everyone else. And there is another provision that if you use email and you try to be cute about it and use it in a way to circumvent the statute, then that's a violation too. Then one person sends it to another one, and it's all one-on-one. That's not going to work either, because if they get all that together and they put it together and they say you're using electronic communication to avoid the purposes of this statute, you violated the law. And then you're probably in a much bigger problem than if you make a good faith error. I think if everyone's going to make errors as this goes on, and I think that the Attorney General understands that. But what they're not going to understand, and they're not going to be, empathetic with, if people are playing with the statute in a way to get around it, and that's going to be the most interest to them.
Okay, then the very last thing I have that hasn't been brought up, and I think it happened in one town already, and I won't mention where, the ability for a committee member to participate in a meeting if they're not present. And I think the new statute allows that. However, it goes on to say that I think you need permission from the district attorney or from someone in order to do that. It isn't, John couldn't call in on a summer day because of his business, for example, and participate in this meeting electronically or over the telephone unless he had permission from, would it be the district attorney? But I think that's already come up in another town, which is why I wanted to bring it up.
Section 20D says the Attorney General may, by regulation or letter, authorize remote participation by members of a public body not present at the meeting location, provided, however, that the absent members and all persons present at the meeting location are clearly audible to each other, and provided further that the quorum of the body, including the chair, are present at the meeting location. And then it says the authorized members may vote and shall not be deemed absent. And that is a perplexing addition. It would seem to me that creates additional problems. But apparently, I assume that the Attorney General is going to
notice and comment session. That's coming up.
Right, yeah, that is subject to a future regulation by the Attorney General. Right now, that has not been promulgated, and the Attorney General has already, in the July 1, 2010, said that's not working yet. We'll get to that later on.
One town's already used it.
Right. It's kind of scary in some ways, unless there's a really, I mean, I don't know how that fits with the rest of it, but someone must have thought it was a good idea.
At an MPO meeting where Commissioner Doherty's disembodied voice was present, and we was actually, we needed him for a quorum, so I guess this was before this regulation, so you can't use it, you can't hustle up someone for a quorum under this law. There has to be a quorum.
Right, exactly, yes.
Right. My only another quick question, you brought up the example of two of the delegates talking to each other by email, and you said that that's not considered deliberation, but that is a public record. I mean, they could, isn't it true that if one of us emails another person and it blows up into a big mess later on, they can actually require us to produce those emails?
Yeah, that's a different issue. That would be production of what would be a public record. That would be a public record, but it would not necessarily be deliberation, because if it's just between the two people, so they're two different questions. It's a public document and subject to disclosure, but not a deliberation.
Yeah, I just want to make everybody aware of the fact that if you do communicate by email and you say things in there that you don't want, that you may be forced to produce that email in the future. I mean, I've had the town, let's say the town of Chatham was sued, and they put this all umbrella thing. We had to produce everything we ever said about a certain subject. They didn't ask us, and it never came to anything. But I was surprised that all that stuff would be.
And I think that that frankly, when you really think it through, the electronic communication has burdens that other communications don't have. For instance, a telephone conversation or an individual one-on-one, because it is a record, it's a document, it's a different thing. I can't remember, but in the Curley era, I know there was a Boston politician from the West End, Martin Lomanzi. I can't remember, you might have read it, but what did he say?
If you don't have to, if you can say it with a wink, wink. If you can say it with a nod.
Yeah, it's something like, don't talk when you can nod, don't nod when you can wink, and there was another part of it, in other words. Yeah, well, it could have been. But let me tell you, do you know it?
Don't write if you can say. Don't say if you can nod. Don't nod if you can wink.
Exactly.
That's the secret to politics.
That's good. And so this was back in the 1920s or something, I think. And so these people were kind of ahead of us in some ways, and whatever. So the email transmissions are definitely what is discussed, and more people are using emails. And as a practical matter, and not that anything, everybody is doing things above board. I have every confidence of that. So I'm not saying this in any way other than that, but those of us who are in public officials who are trying to do the right thing, to the extent that you use emails, that is a more regulated communication than any other communication. I think that's fair to say. So if you're doing your job and you can say something to someone directly to their face or on the telephone, that is a less regulated, because you know that the email is a record, and that's the difference. And I mean, you can.
I talk like Don Corleone, very close, face to face, in a hushed voice.
Right.
I don't sound like one of them. Fred?
I know this is going beyond probably where we should be going, but I understand that phone conversations, or they could talk, that's not a public record. If several members are conferenced in on that phone call, even though there is no record of the phone call, could that become
Well, yeah, if there's a quorum on the telephone, that's a violation of the open meeting law. That is, my point was simply saying that I think that this law is particularly attuned to the fact that electronic communication has been the principal mechanism by which people talk today, and those are records, and they can get those records, and you just have to understand that. So you want to express yourself knowing that whatever you say in the electronic communication may be viewed by the public, and you have to be able to stand behind what you write.
Well, if there's nothing else, if there's nothing else, thanks a lot, and you haven't made it any easier for us, but you've at least cleared up some of the questions we had. So.
Well, if you have any more, we're happy to come back.
And you're going to have to defend us if
don't forget about that exemption. So
okay.
if you want to, we'll come back. Thank you.
Okay, thank you. Well, we've already gone through communications from public officials and members of the public, so we'll now convene the assembly, and we will begin by asking if there's any reports from committees. I see your silence. Do we have a report from the clerk?
Two things. The Standing Committee on Health and Human Services, where George isn't here, I will mention that it will be meeting your first meeting in August. I forgot the date off the top of my head, I'm sorry. August 4th? Okay, so Health and Human Services will be meeting August 4th at 2:30 p.m. with the Human Services Advisory Committee. And then the only other thing I have, I was asked to remind all of you that the AmeriCorps graduation is tomorrow at 9 a.m. at the Children's Arts Center. That's all I have.
Okay, thank you. Is there any other business to be brought before the assembly? Hearing none, move to adjourn. Second? Second. All those in favor say aye. Aye.